Hi everyone, welcome to Facebook Live, 2 o'clock today. I'm Danielle Claffey and I'm going to be answering your questions today in English. So for anybody who has questions, just as we always say, feel free to post those questions below in the feed and I'll do my best to answer those. I'm going to try to check them out while I'm talking and kind of talking through some common issues and some things that everybody's facing right now, and some topics that I think might be of interest. And if I don't catch your questions while I'm talking, then I'm going to go ahead, of course, and look through the feed and answer any questions thereafter as much as I can. So what do we want to talk about today? Obviously, much of our discussions nearly every day are, of course, COVID related and the situation, what's going on. So I think one of the first things I want to talk about, and a lot of questions that I'm getting from many students, international students at the universities, particularly around Georgia, are questions related to F-1 status, OPT, being able to change status, not being able to find employment, different things like that, and what can be done. So the first answer that I'm unfortunately having to give to everyone so far is we don't have any specific official guidance from ICE or from USCIS in terms of what somebody can do if they are nearing a point where they're going to be graduating or trying to file for OPT or file for OPT and have been approved, but they're accumulating unauthorized employment in the US, meaning as you know, with OPT you can only have 90 days of unemployment before you have to secure employment. So that's a big question that's coming up, because I've got several people who have reached out to me that currently at this point have not been able to secure employment, or who have had job offers but now they've been delayed and it's going to put them outside of that 90 days. So thus far at this point, and even speaking to universities, right now we have no guidance. ICE has not told us anything. USCIS has not told us anything in terms of file this, file that, you'll be okay. There's going to be specific authorized periods of stay or guidelines that are going to be issued. So we don't know whether to advise individuals to file for extensions or so on. But at least what we believe at this point is that, those agencies are aware of those issues, and we're hoping that, of course, there will not be penalties and that they're going to come out with guidance soon. So we're hopeful that that's going to come out in the next week or two, and we're just paying attention to that daily so that we can make sure and know really what students are looking at and what they're facing in terms of being able to work in OPT status because they don't have unemployment, or they may have an offer, but that offer is 120 days out, and so they're potentially violating that 90-day rule. So as soon as I hear anything, obviously we will update as much as possible. I've had several students and recent grads contact me in that regard. Of course, the other issue too is not just having the 90 days of unemployment, but it's also nearing the expiration of one's OPT, but not being able to change status because they don't necessarily have a job offer that they may have had before all of this started, but that they also can't depart the United States due to canceled flights, shutdowns, closures in their home countries and so on, not knowing what to do there. We at least have a better, more definitive answer in that regard, only because obviously it goes back to the whole idea of always having to maintain your status in the United States, not wanting to overstay. And so a strong possibility in those situations, if somebody's unable to have an employer petition them or sponsor, or there's no family-based options, for a change of status or so on, one possibility that we're definitely looking at is filing for B2 bridge applications for requesting a change of status and an extension of status, in the hopes that that will bridge somebody's expiration of somebody's underlying status. Again, specifically if we're talking about OPT or anything of that nature, to at least be able to provide somebody the eligibility and the ability to continue to maintain their authorized period of stay in the United States, meaning their ability to remain here without accruing unlawful presence in the U.S. So again, something to be really clear on that can be confusing, and that I've also had a lot of questions about, is really what's the difference between what does it mean when somebody says an authorized period of stay versus what does the accumulation of unlawful presence mean? What does that mean for somebody who's here on F-1 status and nearing the end of their OPT time? What does all of that mean? So basically, a period of authorized stay in the United States is different than the question of accumulating unlawful presence. So a period of authorized stay means that an individual has filed an application that's pending or approved that's authorizing that individual to remain in the United States during the pendency of that application. And so the difference there is that, for instance, let's say somebody's here on B2 status as a visitor, or B1 status because they entered for a work conference or for business meetings or something of that nature, but now they're faced with this COVID situation where they can't depart the United States under the circumstances. And so what that means is that we're suggesting that these individuals, in order to protect their ability to remain in the United States without accruing unlawful presence, is that we're instructing them to go ahead and advising, and of course we can help with the filing of B2 change and or extension of status, if one is already in B2 status. So during the time that application is pending, they are in an authorized period of stay, okay? Versus what's called unlawful presence. And this question comes up a whole lot, in particular among students, so among those who are in F-1 status. So just as a reminder of what those rules are with respect to unlawful presence, when somebody enters the United States on an F-1 visa and they're engaging in their degree program, their program of study, and then they graduate and they hopefully have timely filed for OPT, and then they're working in OPT, whether it's for their first 12 months or they may be STEM eligible, so then they have their additional 24 months of eligibility under STEM. Once that person completes their studies and finishes their time, maxes out their time in OPT, if they are not able to successfully change their status, meaning selected for an H-1B or filing for some other change of status, possibly an O-1 or an L-1 or some other type of non-immigrant employment-based visa, then that person, once they are out of OPT status and they're no longer in F-1 status, are technically no longer in a period of authorized stay in the United States because they're out of status. But the difference for somebody who held F-1 status is they will not at the same time be accumulating what is called unlawful presence in the U.S. And so that's a big difference and also something to consider in the context of all of this. So unlawful presence means any number of days that an individual is in the United States without papers or without proper authorization to be here, they're going to accumulate unlawful presence day by day by day. And the moment that somebody has 180 days of unlawful presence in the United States, and then they depart the U.S., they're going to be subject to a 3-year bar before they can return to the U.S. And once somebody has a full year of unlawful presence in the U.S., they depart, and if they try to re-enter, they would have a 10-year bar before they can re-enter the United States, unless they can otherwise apply for a waiver, meaning forgiveness of that time to be given permission to re-enter. The difference for those in F-1 status is that as it stands right now, those who fall out of F-1 status or their OPT expires, even though they no longer have a specific period of authorized stay, they're not actually accumulating unlawful presence. And the reason is because in the regulations for those in F-1 status, as well as J-1 status, and corresponding dependents as well, that is when the individual enters the United States, you'll notice on the I-20 or on the DS 2019, there'll be a notification rather than a specific expiration date noted on the I-94 or on your stamp on one of those documents. You'll see that notation of D/S. And that means that the person is authorized to be in the U.S. for the duration of their stay. There's no specific expiration date like May 1st of 2020. And what that means under the law is that after that date, after they're no longer in OPT or valid F-1 status, they don't begin accumulating unlawful presence, because there's no exact end date. And so it's something that's really come out of the law with respect to those regulations that makes it such that somebody who is in F or J status, who's subsequently graduated or discontinued or completed their OPT time, will not begin accumulating unlawful presence in the United States, okay? Which is certainly a benefit and a bit of a cushion, because it does prevent that individual from potentially being subject to one of those bars if and when they do depart and want to turn around and re-enter, okay? So that's very important. But what it does not change, though, is the fact that individual still, this golden rule that I always talk about, they still have to maintain their underlying status in the United States, meaning also their authorized ability to be here in the US. And the only way to always do that is to maintain your status, to extend your status, to change your status. So that brings me back to the issue at this point of, what does one do when they're about to run out of their OPT time? I just spoke to somebody this morning who is currently employed in the healthcare industry, and she's doing some amazing work because she's working directly with COVID patients, and she's working in OPT status because she graduated with a nursing degree and so on. And so, but she is concerned because her OPT runs out in June. And so she was asking me, look, what do I do? What do I do if an employer is not willing to sponsor me? Can I change my status? What can I do? And I talked to her about what her options are, and we have to really kind of think outside the box sometimes and discuss some options and things that may not have been before, but may be very relevant now. She's working as a registered nurse in the intensive care unit of a hospital caring for COVID patients daily. So I talked to her, hey, let's talk about the possibility of changing your status to an H1C, for nurses, specifically registered nurses, and see if we can pursue a change of status for you in that regard through an employer. So again, that's one way of kind of thinking outside the box, and something where an employer may not have been so inclined before, or more difficult process, but now things have changed, and that might be a very viable path for her. And so that's something that we're going to discuss more. And again, it also takes me back to, I've had many calls from individuals to say, hey, listen, my mom just came over. She only came over, in January, February. I just had a baby, and she came over to visit with her grandchild and help me out for those first several weeks. She had her plane ticket to return. She had no intentions of staying. She's visited before. What do we do now? She can't return home. She can't leave the United States. Her flight has been canceled. So of course, my advice to her, to the daughter in this case, was your mom needs to go ahead and file a B2 extension. It's an I-539 extension of her status in the United States. And the reason is because she can't leave. She's not doing it intentionally. She has no intention to remain permanently in the U.S. or to violate the terms of her visitor status. But the fact is her status is expiring in about another 45 days or so. And so I encouraged her to consider starting the process immediately to file an extension of status. And the reason that I say to file that extension of status immediately is because I also can't guarantee when an extension of status will be approved, okay? So we've certainly seen situations oftentimes in the past where an individual will file a B2 extension of status very shortly before the current one is set to expire, meaning the I-94 card and this specific expiration date notated on your electronic I-94 card or the old I-94 card. And so the reason that I would recommend filing that extension of status as quickly as possible, knowing the circumstance she's finding herself in now, is because I don't want her to then be waiting 4 or 5 months before she gets a decision on an extension, potentially bringing her very close to or even past when her next 180 days that she's requesting would hopefully be approved. We've seen lots of situations where that B2 extension does come through, but it gets approved after the person has already exceeded the time that they're requesting on that extension of status application. So for those reasons, in an effort to make sure that an applicant is staying on top of their authorized period of stay in the United States, we're always going to be recommending to really take some time and file it, giving yourself as much advance time to allow for the processing of these applications as possible, because we simply just don't know how long it's going to take for USCIS to issue decisions. I'm hopeful that under the circumstances, and because CIS recognizes the issues with COVID, that these B2 extensions of status will be reviewed on a quicker basis. As far as we know, with respect to USCIS right now, the main service centers themselves are up and running and processing applications, but with the exception of, from what I've heard, the Vermont Service Center. So apparently, and out of the blue, suddenly the Vermont Service Center was not open and was not functioning. I don't know if that's different. That was just a few days ago. So I don't know if there's been a change there. So we can't guarantee, of course, we can't guarantee anything that's going on right now, but obviously we want individuals to take the best precautions that they can if they're here and in status, to do their, make the best effort they can to maintain and extend their status. Even if an extension of status is filed, but the person ultimately is then able to depart the United States at some point because, restrictions are lifted, their home countries reopen in terms of allowing individuals to return and so on, at least you can then show to USCIS that you made every effort you could to file the proper documentation and extension, that you were doing your best to comply with the law and so on, so that you have a good record going forward for the next time that you attempt to either re-enter the United States as a visitor or on a B1 or a new program of study on a student visa. Whatever it is, you want to show that you had no intention of violating your status and that you made every effort you could to maintain your status. So that's going to be, very important going forward. So I do see one question that's popped up, which says, have you seen delays in the processing of applications? Well, it's a hard question to answer yet. And the reason is because for us, from what I'm seeing, not enough time has necessarily passed. If we're talking really from kind of February until now, we're not seeing any specific delays because not enough time has passed in order to determine, whether an application is now taking quite a bit longer than it normally would, okay? But what is resulting in delays is the fact that USCIS is not conducting any in-person appointments, nothing face-to-face. So no biometric appointments for fingerprints, no interviews, that sort of thing. So that in and of itself is obviously causing a delay. I had a number of clients that had been approved for naturalization applications recently, and then had their oath ceremony scheduled to turn around and have them canceled. So that's, of course, the delay, right? Because the person was about to be sworn in as a U.S. citizen, but now they're facing a delay because they don't know when that's going to happen again and when those activities will resume. The same goes for the scheduling of interviews. Several individuals over the course of late February all through March and into April now that had green card interviews scheduled or their naturalization interviews scheduled. Typically we receive notice about 3 to 4 weeks in advance of the dates of those interviews. So we were receiving all kinds of interview notices, but then we were having to pay attention daily to the local field offices where these interviews are conducted by the officers. And in many cases, offices were closing down, independently of one another. One office may be shutting down for a particular day or two or several days or that particular week. We saw that a lot with the Montgomery field office, but not necessarily in Atlanta. So I was still attending a couple of interviews in Atlanta with clients at the same time that we were actually starting to hear about cancellations in Montgomery. And then all of a sudden, Atlanta followed suit and everything started getting shut down. So as of right now, everything with both USCIS as well as the immigration court system is shut down for anything face-to-face, in-person, and non-detained immigration court hearings through at least May the 1st. And those closures have just been extended and extended, periodically. So we're just having to pay careful attention and then notify any clients who have interviews scheduled or court dates scheduled after that May 1st date to make sure we're staying on top of that so that we're notifying our clients, hey, listen, I know you were scheduled, but they now extended the shutdown another 2 weeks or whatever it is. So in terms of seeing delays, the answer to that question is yes and no. And in terms of the true extent of delays and what's going to happen, it probably is going to take a little bit longer to see how that's really going to play out based on applications that we're filing now or have filed in the last couple of months, and then seeing how long it's going to take to process. Because the other issue is, again, biometrics appointments. So they're not scheduling biometrics, where you go for your fingerprints. But what immigration is doing is they're using old or previously captured biometrics and trying to use those in order to refresh to still be able to process applications. So that's good that they're at least doing that, but it still doesn't fix the issue of in-person appointments. So I have no doubt that will prove to cause delays. I just don't know yet what that will look like in the long run because, again, not enough time has passed. So that also brings up one other thing that I want to talk about kind of in closing, and then again I'll look and see if there's any other questions that come in, and I'll also leave my email address and my phone number just in case. So I do a lot of federal court litigation here at our office, and what federal court litigation means is that we have the ability to file lawsuits in federal court when somebody's application has been pending for a length of time that's what we deem to be unreasonable, meaning it's outside of processing times, and the applicant or we on their behalf have done inquiries and info passes and phone calls and written requests for updates, and we just haven't gotten anything. And then somebody will eventually reach the point where they're tired of waiting, and they'll say, what else can we do? And that's where I'll start talking about being able to file a lawsuit in federal court. And basically what that lawsuit does, it's called the mandamus, and it forces USCIS to issue a decision on the application and really to take whatever steps are necessary in order to complete that application. So it might be refreshing fingerprints, or it might be providing an updated medical exam, or it may even be a second interview, right? And so I've been paying close attention to what's happening with federal court actions, specifically mandamuses and things like that, in the context of what's going on with COVID, because I know they've said no in-person interviews, right? But I just heard recently, because I kind of pay attention to what other attorneys are doing around the country, and there were a couple of other attorneys that had mandamuses that were pending that were reaching the point where they'd be looking for a decision in action, which is usually about 70 to 90 days after a federal court complaint is filed, where we'd be looking for a decision to be able to finish up the case. And it turns out that in some situations, offices around the country are scheduling special interviews where they are, very special circumstances to bring the individual in for their interview because there's a mandamus pending. And so they just take very careful precautions, whether it's masks, gloves, limited number of individuals are permitted in, things like that. But the point is, I am actually seeing that these local USCIS officers are responding to pending federal court complaints and still taking action in order to resolve these cases and hopefully get decisions out. So it does not mean that just because, what it doesn't mean is that you could still have, you could decide to go ahead and file a mandamus because your green card application has been pending for a couple of years and no decision yet. And filing that mandamus in federal court is not going to be automatically doomed because of COVID. So one, as I said, there's a possibility they may still schedule a very, special, careful interview under, of course, safe conditions. Or the other possibility is a lot of times when I file lawsuits, for one reason or another, there might be a special circumstance where the government attorney and myself agree to hold a case in abeyance, meaning to kind of just hold the case there in place for some other issue to be resolved. Okay, so in this case, let's just say COVID. And the government attorney and I may go back and forth and say, okay, in light of COVID, the Atlanta office won't schedule an interview right now, but we'd like to hold it in federal court to keep the case open so that when Atlanta does resume activities and interviews, we will get that case right back in queue to get that interview scheduled because we have this lawsuit pending. So it will still serve as a means and an ability to make sure that we're filing in federal court to continue to get that case pushed through after long delays, even in spite of COVID. Okay, so I see one last question before I close out. Do you think DACA recipients will ever receive a long-term work permit? Okay, so that's a good question. So of course, DACA right now is deferred action, meaning temporary. And that means work permits are issued in increments of 2 years, and you can file to renew. And it used to be that you'd have to file within just a certain period of time before the expiration date, and then up to 6 months. And now we know that DACA renewals can be filed really at any time. And so we're actually advising many of our clients and anybody that we talk to go ahead and file your DACA renewal, even if you still have a year left on your current DACA. And here's the reason why. It's not meant waste your money or to overlap so much with your current DACA with the new DACA. The issue is that the Supreme Court heard oral arguments several months ago on whether DACA was going to continue or whether our current administration did have the ability or does have the ability to terminate DACA. And before all of this COVID really came to be, where it is now, we fully anticipated that the Supreme Court would likely issue a decision right around June in terms of how the Supreme Court works in sessions. And so they issue decisions in groups. So we anticipated around June we'd be getting a decision on whether the Supreme Court says that our administration has the ability to terminate DACA. I'm concerned that the Supreme Court was going to rule against DACA and possibly lead to its termination. So, of course, we're advising everyone, look, if you're eligible to renew your DACA now. It doesn't matter if it expires in a year. Then you'll get another whole year on top of that to maximize and keep getting 2-year increments as long as you can. So that's still what we're advising because we just don't know what's going to happen. But in terms of a long-term work permit, I don't necessarily see DACA transitioning into something that would involve a long-term work permit, in as much as that I'm going to always remain hopeful that DACA will eventually turn into the DREAM Act, will eventually turn into something permanent, which means a path to a green card and a path to citizenship and so on. So I can't answer the question in terms of long-term for DACA because as of right now, we don't know any more than what we knew each time bills have been presented and proposed and unfortunately have yet to really pass. So no answer to the question of a long-term work permit, but again, continue to renew as much as you can while DACA is still available. So I hope I've answered some good questions and given you some good ideas. If anyone wants to follow up with me, again, my name is Danielle Claffey, and I'm going to spell my email address. It's DCLA, F as in Frank, EY @immigration.net. And then my direct phone number is 404-949-8151. So I hope everyone stays well and safe and healthy, and we'll talk to you soon. Take care. Bye.